Today is February 1, 2012. This is our third class meeting for Children and Justice. We're a little bit behind. We're wrapping up Learning Module 1, but we're going to dive right into Learning Module 2. And I started by expressing the fact that I'm not surprised there was some level of, I don't know what the right word is, anxiety or unhappiness about the outcome in State versus Galloway, and that was the subject of discussion board 1, or your first discussion board, and it had to do with interpreting the words of a statute and how that happens in a criminal opinion. MTS did that, and many of you referenced MTS in your discussion board posts. And of course, Galloway was the main part of the discussion board posts. And what I want to do now is just address that a little bit and let you know that, as I did in that podcast, Galloway was just about whether he should be guilty of a 4th degree or a 3rd degree, not that he should go free and not that he's not responsible or that he is responsible. He was charged with murder and a number of other offenses. In order to understand why endangering is what it is and why Galloway was treated the way he was, we need to get a sense of why there is an endangering statute, what its origins are. And it's somewhat related to the section of the statutes known as Title IX. And as I said to you before we began to record this session, Title IX is the enabling statute and related laws that govern how the Division of Youth and Family Services is responsible for child abuse and neglect in the state of New Jersey. There's a bunch of different provisions in there that govern DYFS. And among the provisions are a number of different definitions of child abuse and neglect. And we are continuing to talk about definitions in words. So it's helpful, I think, to take a look at that before I get back to Galloway and Chapter 24, or endangering the welfare of a child. I've put on the big board the definition of abused or neglected child. And you can see, as set forth in, when you see NJSA, can someone tell me what they think that stands for when you're reading these criminal cases or civil cases or articles? Can someone tell me what they think that those initials stand for? You'll see them over and over again all year. Well, how about the first 2 letters? Let's scrap the last 2. NJ. New Jersey. Statutes. Forget about the A, you won't know that. But maybe you would. But that stands for annotated. And I usually drop the A because back in the day, publishers would put out the New Jersey statutes, and as a bonus, you would get annotations. And that simply meant, here's the statute, abuse or neglect. Abuse or neglected child means, and at the bottom of the statute, there'd be annotations. A law professor would opine or give his opinion about what the laws mean. They would also quote cases and say, this statute, which is the first part of the page, was interpreted by the court in this case. Here's a law review article about that. So publishers would put annotations around, or typically after the statute. This might even be annotated. This might be a digital version. Let me see. No. So nowadays, when I cite the New Jersey statutes, I just put NJS, because the annotations, I don't think the A is relevant. But anyway, that stands for the New Jersey statutes. The 9 is the Title IX. The 24 in endangering is Chapter 24 of 2C, which is the Criminal Code. Title IX, colon 6-8.21. Just some arbitrary letters and numbers. Don't matter. Don't mean a hill of beans when it comes to the law or anything else. They could have put any set of numbers in any kind of sequence as long as it was orderly in front of these laws. So in Title IX, you have this 6-8.21c. Abused or neglected child means a child less than 18 whose parent or guardian, as herein defined, does the following. Creates or allows to be created a substantial or ongoing risk of physical injury to such child by other than accidental means, which would be likely to cause death or serious or protracted disfigurement or protracted loss or impairment of the function of any bodily organ. Whoa. Here's a mouthful. A child whose physical, mental, or emotional condition has been impaired or is in imminent danger of becoming impaired as the result of the failure of his parent or guardian, as here defined, to exercise a minimum degree of care, doesn't end yet, in supplying the child with adequate food, clothing, shelter, education, medical or surgical care, though financially able to do so, etc., etc. So this is one definition of an abused or neglected child. If we had Title IX here, there'd be two other blobs of words that attempt to define abused and neglected child. And they were passed at different times. And at times they are somewhat at odds with one another. Some have argued that they are so broad as to be unconstitutional. Among the prohibitions is, by the way, what they all have in common is it's about caregivers. DYFS investigates abuse or neglect by caregivers. Bad guys who wander the streets hurting kids are not DYFS's jurisdiction. They're about caregivers, persons who have supervisory authority over children who exploit that position, who exploit that access and opportunity. And the most frequent DYFS investigation involves parents, or moms, or dads, or moms' boyfriends, or uncles, or babysitters, or foster parents, or folks like that. But there are a variety of ways that DYFS could be involved in investigation, as long as that person has some kind of supervisory role. Teachers, right? Things like that. Most of the time it's parents, or caregivers, or guardians. So that's what DYFS is all about. Every definition in there, all those blocks of words, all talk about parents, or caregivers, or custodial persons. There's one little section that doesn't say that in one of these blocks of words. And it says something to the effect of the employment of a child in an industry or vocation that could be injurious to the child's health or welfare. This Title IX was passed, in large part, there have been a number of amendments, at the time of the turn of the last century, from 1899 into the 1900s, somewhere around there, maybe a little later in time. But the point is, we were an agrarian society. Many of us were farmers. And when we weren't farmers, in the big cities, we worked in factories. Right? And we were churning out stuff, whether we were sewing stuff in little rooms in Lower Manhattan, or we were in big factories in Rahway or Elizabeth or whatever, churning out widgets or whatever we were making in New Jersey along the Route 1 Turnpike corridor over there. Kids and adults worked in factories, and it was a problem. I mean, we have this problem arguably in Asia now. I mean, I got a couple of Apple products here, and Apple was accused in the New York Times about 5 days ago of having the glass for those iPads manufactured in terrible conditions in China, including the use of child labor. So you have one little snippet in there in Title IX that speaks of an act of abuse or neglect that doesn't involve a caregiver, right? Because if you own a factory or you own a sewing shop in Lower Manhattan and you have kids working there, or you have a farm, and there might have even been exceptions for farms because it was expected that kids would work on farms. So I need to look at that more closely. But in any event, if you ran a business, you could be investigated by DYFS, apparently, based on this statute. But I've never, I've been in the child abuse and neglect business for 2 decades, and I never had a case involving a sweatshop or kids in a bakery or anything like that. It could be out there. Everything else in Title IX is about caregiver exploitation. Every other definition. Professor Cannell argues that parts of it are probably unconstitutional. I don't know if I have the other section here from Title IX. Let me see if I have it on Blackboard. No. Anyway, I remember some of these things. The habitual use of obscene or profane language in the presence of the child. Okay, well, you may say, well, that's not good. But child abuse and neglect, maybe we want to protect kids, right? But from this definition can spring or arise criminal responsibility. Galloway shook the child to death, but would be equally responsible if he cursed in front of that child habitually. Because Chapter 24 takes us back to Title IX, and I'll show you how that works in a minute. But among the ways to be culpable or guilty of child abuse or neglect was the use of dirty words in front of the kids. Vexing the child. Like I said, 2 decades. 1992, I got involved in child abuse. I never had a vexing case. I don't even know what it means. So, anyone who posts in a cyber cafe a definition of vexing, you'll be helping me out a little bit. Look it up, and you ain't going to get any bonus points, but I'd be interested in knowing, how do you vex a kid? Is that like black magic? Does someone know without looking it up what vexing is? Being vexatious or vexatious or vexing?
I thought vexing was annoying.
Maybe. I don't know. I couldn't challenge you on that. We need to look it up, So if you annoy your kids, I'm not so sure, man.
Irritation or annoying.
Irritation or annoying?
Extremely annoying or displeasing.
Well, now we're getting there. Extremely annoying or displeasing. Okay. There's an easy glass made of Asia. Anyway, you see that though? That's why Connell says it might be unconstitutional. What kind of law is that? Vexing? Being extremely annoying to your kids? There may be a second and third definition. We're looking on the iPhone here. I'd like to see Webster or
they're all similar.
What's that fancy book from England there? The Oxford Dictionary. Well, you know what? We need to go. See, the thing is, we need to look at the historical definition. Because vexing may have changed. Words are beautiful. I love words, and they change. People use words, and they change. I don't know what vexing meant in the turn of the 19th century into the 20th century. Anyway, so that's in there. As well as things like you just saw, which I will put back on the big board. In fact, I'm going to go to give me a home page. I'm going to go here. NJS 9:6. Let's see what happens. There's some lawyer's blog. Oh, this is the mandatory reporting statute. 9:6-8.10. We're going to talk about that later. I think that's reproduced. Yeah, here's the other one. One of the other ones. There's 3 of them. Come on. There it is. Employing or permitting a child to be employed in any occupation or dangerous to the morals. The habitual use by a parent or person having custody of profane, indecent, or obscene language. Here's one that Connell probably would argue emphatically is unconstitutional. Look, why would he say unconstitutional? What lawyers mean by that is laws need to be precise. They need to put us on notice about what's right or wrong. I think I was screaming that maybe the first class about we're a notice state. You can't pass a law making something criminal today that was happened yesterday and hold someone responsible for that. I forget what kind of wacky example I used. Well, so laws need to be and words need to be reasonably precise. But here's what gets Connell's goat. Look at this one here. The performing of any indecent, immoral, or unlawful act in the presence of a child that may tend to debauch or endanger the morals of that child. We're getting kind of broad here. Indecent, right? Immoral. Now, unlawful, okay, obviously that begs the question. If it's unlawful, it's unlawful. Right? Now, here's the problem. I'm going to click over to... Oops. Cruelty. Yeah. Here's the problem. Maybe it's not so bad to have that Title IX that's broadly drafted, that goes after parents, arguably, if they use dirty words and are vexing to their children or they do indecent and immoral acts. Good parenting should not tolerate such stuff. And again, the civil laws ought to promote the ideal, right? Who hasn't used a curse word maybe in front of a kid, right? That doesn't mean you're a bad parent, or you ought to go to jail, or you ought to have the government come into your home and put your kids in foster placement. Nevertheless, they use words like habitual over and over again, immoral, unlawful. So, you really want the ideal when setting up a model for how we want to care for our kids. And if this is violated, because Title IX is in large part a civil statute, what can happen? Well, DYFS can come into your life and straighten you out. Tell you, listen, that's not right. You need to conform your behavior. And if you're really bad, they might take away your kids for a little bit of time until you get rehabilitated. Or if you're so bad, you're so unfit, you may lose your kids, because this is about the protection of kids. That's where it begins and ends in Title IX with the Division of Youth and Family Services. This whole set of rules in that 40 or so pages in Title IX is designed to protect kids from harm from their caregivers. And harm can arise in a variety of ways, and they attempt to describe them over and over again at the cost of being broad in some places. But what's the outcome? The government comes and says, hey, you shouldn't do that. You ought to do it this way. I'm obviously understating it, but that's the upshot. Sometimes if you were cursing in front of your kid habitually, what are they going to do? Put your kids in foster care, at least not the first time. They're going to come in and try to remediate, right? Try to remedy that situation. By the same token, and we're getting to Galloway, by the same token, this statute, Title IX, makes it criminal to do those things. In fact, this one here, 963, that's on the big board, takes these definitions I just described to you and says, again, any parent, guardian, or a person having the care, custody, or control of a child who shall abuse, abandon, or be cruel or neglectful, on and on, shall be guilty of a what? A crime of the fourth degree. So this DYFS law not only sets it up so the government can peek into your home where kids' health and safety is at risk, but they can also charge you, right? Built into Title IX is this 963. It's a fourth-degree crime. But it gets even more involved than that if we take a look at, and this law firm put this right here at the bottom, which is good. We looked at this last week. This is Galloway. If you engage in sexual conduct which would impair or debauch the morals of the child, we say that's implied. We never worry about impairment or debauchery in New Jersey. Or who causes the child harm that would make the child an abused or neglected child. Okay, there's some elements there. There's some words. How do you get in trouble under 24-4? When you have sex, when you engage in sexual conduct. Okay, that's one way. We draw a big slash. Or you cause the child harm. Okay, you need a child. You need to be a caregiver or assume care. Cause the child harm. Okay, what kind of harm? Oh, the kind of harm that would make them abused or neglected. What's that mean? Remember, we're in 2C. We're not in Title IX. Right? We're in the criminal code. Okay, what does that abuse or neglect mean? Where do we find that out? Oh, we go to Title IX, the Dyfus Law. Wait a minute. We got to go to 961 and 963. So the criminal statute, where the consequences are severe. By the way, nowadays, Galloway would be looking at a second degree or a third degree. The second degree is 10 years in jail, with up to half of that sentence without parole. 10 years, 5 years, when you don't ever get to talk to the parole authorities until the 5 years elapses. So we're talking serious business here. Okay? Theoretically, if you are profane or indecent or vexing, and you're the father or the mother, or you assume legal responsibility, it's the same second degree. 10 with a 5-year mandatory minimum before you see parole. Why? Because this criminal statute sends us back to 961, 963, and 968.21. It sends us back to that Title IX book with all those wackily broad definitions. And if there's one thing that the courts don't like, and what we as Americans don't like, are criminal laws that are broad, that can be capable of a million different interpretations. We need our criminal laws to be reasonably precise. Well, this is one area where, as I said 3 times, some argue, including the well-known law professor from New Jersey, John Connell, that this is probably unconstitutional. Despite Professor Connell's beliefs, it's never been overturned by the Supreme Court and has been specifically upheld by the Supreme Court on a number of occasions. Professor Connell argued, and I don't want to get too inside baseball here or too inside the law, that this law here that says it's a 4th degree crime was superseded when they passed the criminal law 24, the endangerment, the one from Galloway. And what he means by that is, if you pass a new law that covers the same stuff as the old law, well, then the new law is operational. And the legislature doesn't always go, you know what, we need to put a big X through Title 963 because we passed a new law that covers the same exact behavior. You know? Let me tell you, they leave things dangling all over the place. The smartest people in America and in New Jersey leave things dangling all over the place when it comes to laws and statutory development. But they didn't do that. And someone finally argued, what Connell argued, the professor, that this is overruled by Chapter 24, the Galloway law, if you will. The Supreme Court said, nah, not really. This law is specific to caregivers, and it goes up to age 18, and there are different interests involved. And I'm wildly paraphrasing. I haven't read that case in years. But the point is that that issue was discussed by the Supreme Court. They said, nah, we prosecutors and defense attorneys like this law because it's only a 4th degree crime. Nearly any horror that you could perpetuate upon a child, you can fit into that law. Why? Because that law says abused or neglected is all those blobs of definitions, which run the gamut from working kids in bakeries to killing them. Right? Dirty language to molesting them. It's all in Title IX. There's about 35 different definitions of what it means to be an abused or neglected child in New Jersey. Like I said, they run the gamut from de minimis behavior to outrageous behavior. And why do we like it as prosecutors and defense attorneys? Because the legislature, when they pass a new law, sometimes a law that's a bit draconian or severe or harsh, you know, everybody who touches a child should get life in prison in Oklahoma. Well, we're in New Jersey, but when they pass new laws that are harsh and severe to go after some class of criminals, you cannot get out of jail more than this many years. You shall get a double sentence. Whenever the legislature attempts to tackle a societal problem by ratcheting up the punishment, they make a list of the crimes that the new punishment applies to. So if they came up with a law and said, anybody who touches a child in a sexual way shall get double the sentence and not be eligible for good time credits in jail, and they can't work in the library or the commissary in jail. They have to sit in their cell, and they're not allowed to watch TV either. We're going to make it as miserable as possible for these perverts. That's the new law. And it shall apply if you're guilty of endangering the welfare of a child. You saw these laws already. Aggravated sexual assault, aggravated criminal sexual contact, criminal sexual contact. All these laws. And they never remember to write in 963. So when you're trying to work out a plea agreement, and we'll talk more about plea bargains, it's not a dirty word. It is respectful and helpful to children, women, and victims in this state and every other state. It's a necessary, I wouldn't even call it an evil, it's a necessary thing, plea bargain. This is a little bit of a plea bargaining tool here, because they never remember the legislature to go and include Title IX in there. And nearly anything you can do to a kid, like I said, you can fit in that law. So, going back to Galloway, the Supreme Court was dealing with whether Galloway ought to be responsible, not because he had a legal duty. We knew he didn't have a legal duty. He didn't give birth. He didn't sire. He wasn't the father of this child. He wasn't the child's teacher. He wasn't the child's foster parent. There was no legal documentation or legal relationship. He wasn't a teacher or a jail guard or probation officer or anybody else like that. He was a guy who was hooking up with the mother and living in the house. And, correct me if I'm wrong, did he watch the kid once in a while when she went to get a pack of cigarettes? No, I'm using that metaphor. When she went out for a little bit? Okay. And you read the case, but the court kind of said, listen, you know, we understand that kind of intuitive appeal that this has, that Galloway ought to be someone who has assumed the responsibility for the care of a child. But we think the legislature meant something more than that. We think when they included that other section, legal duty to care or assumed responsibility, that was something important, substantial, big time, meaningful. It was essentially the equivalent of the relationship and duty that a parent has. You know, there is no greater duty, there is no greater connection between two people, legally, morally, socially, biologically, than parent-child, right? That's a big-time relationship. And to exploit that relationship is far worse than exploiting some other regular person who you have no relationship with. You bop somebody over the head at Willowbrook Mall because they cut in line on Black Friday, that's one thing. You bop your kid in the head because they won't do their homework, that's something fundamentally different. And the legislature says, and it ought to be treated severely. And they also said, and I'm paraphrasing, when you want to put this on somebody, that they assume the responsibility for the care of a child, that needs to be a big-time thing, too, as well. That needs to be something substantial. It needs to be the functional equivalent of the parent-child relationship. And could we say that Galloway was in that kind of relationship? Hey, maybe you could, maybe you couldn't. Ultimately, these things are fact-sensitive. If you go back to my hypothetical at the end of class last week, I told you that Jerry Pasillo, let his daughter Gabriella go up to Suntan Lake with the guy next door, Manny. He was his dear friend. They come over and barbecue with one another. They watch the big game together. The kids play in the yard. Manny's kids play in Jerry's yard. Right? But Manny taking Gabriella with his kids up to Suntan Lake, did he all of a sudden become the legal equivalent of the parent? Did he all of a sudden have this lofty position in Gabriella's life like a parent does? Again, I'm telling you what the Supreme Court said. You can say, well, I don't care. But there needs to be a difference, right? Otherwise, some of the least substantial relationships could be considered this assumption of responsibility. And the court said, no, that's a big deal. That's a big deal. And that's not what Galloway was. Now, arguably, Galloway might have been that. What did the court say? What did the court say? What should we look for in determining whether someone assumed responsibility? If you were the judge and you said, well, I want to charge that Manny, what would we need to know about Manny and Gabriella and Jerry and the families next door to one another? What did the court say is required for someone to be a supervisor, to have assumed responsibility for the care of a child? What did the court say the things are that are? They said what it is and what it's not. So by saying what it's not, you might be able to say what it is and what we ought to look for in Jerry and Manny's relationship. Go ahead.
I think it's, I'm just going.
It's okay. We're just here
That
talking.
is like continuous and consecutive not guardianship, but it has to be consecutive and continuous.
Continuous.
Of a relationship.
Very good.
Not every once in a while.
Not once in a while. What?
More on a regular basis.
Yes. My recollection is they used words like continuous, ongoing, frequent, not haphazard, not once in a while, not infrequent, right? So a regular person in the neighborhood could assume responsibility, but the court felt that it had to be continuous, ongoing, frequent. So you could have a babysitter who watches Gabriella every Wednesday after school. They may fall under the top one. But Manny inviting the kid to go up to the lake one day and had never done it before and never done it since wouldn't be someone who assumed responsibility for the care of the child. Because it wasn't ongoing, it wasn't frequent, it wasn't continuous. It was the opposite. It was infrequent. I think they used the word occasional too. Okay? And the court was also implicitly commenting about what the statute means. You are basing liability on bad parenting that arises from Title IX. And you can't just think about Galloway or Anthony Galloway, right? You need to think about how the law impacts all these cases. Because the same batch of words would cover Manny whether he molested the girl or whether he cursed in front of the girl over and over again. Because the theory upon which Anthony Galloway was prosecuted was that he caused the child harm that would make them abused or neglected as defined in Title IX. That's how they got Anthony Galloway on that particular charge. And what we say about Galloway, this is the thing that one must be mindful of in the law. It's not only the case before the courts, it's all other similar cases that might be impacted by the case before the courts that they need to think about. So if they react emotionally, or they want to get Anthony Galloway, and they want to apply this very broadly, well, that same broad interpretation is going to apply to the person who keeps the kid in the bakery for 14 hours, the person who vexes the kid, the person who profanely expresses himself in front of a child repeatedly. So that's how Galloway was resolved. Words are important. Words help define jurisdiction. They help define outcome. They help define criminal responsibility. And they don't always mean what they say. Now, that's a nice segue to, let's take a look. Well, before I put Myers back there, traditionally, this statute has really been broken down in two at that course disjunctive. There's two ways to be culpable under the endangering statute, and we've observed this many times. One is the sexual abuse, and after the order, that's the physical abuse part of the danger. So we use, and the government uses, and prosecutors use, or causes the child harm, blah, 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 for physical abuse cases. Kids that are beaten with belts, kids that are shaken to unconsciousness, kids that are punched or battered or swung or have their bones broken or their ribs squeezed or whatever. Those kinds of serious cases of battering wind up in Part 2. causes the child harm that would make them abused or neglected. Now, conceivably, nearly anything, any kind of terribly bad parenting could wind up there, but criminal prosecutors are not going to be involved in those kind of cases. There's lots of ways you can harm a child physically that may be actionable by DYFS and possibly actionable by law enforcement, that most of the time law enforcement defers to the civil authorities, to DYFS. So you're going to wind up with your serious batterings that wind up in law enforcement. And that's how we go after them in that second section there. Same way they went after Galloway, that second degree physical abuse. Which takes us right into Professor John Myers and your book, where he attempts to round up all the definitions of physical abuse. And if it hasn't sunk in yet, this is one section where you clearly must conclude that words are imprecise and it's real hard to come up with a good definition of anything in the law, much less physical abuse or child maltreatment. Myers writes, physical child abuse is non-accidental physical injury. You can find the definitions, and we just looked at definitions, in a variety of places. Criminal codes, that's 2C, endangering, Galloway, right? Statutes governing the juvenile court, we didn't look at those, but there's laws that govern the juvenile court, and child abuse reporting laws, that's Title IX. Part of the reason why physical abuse is hard to define and lawyers and child advocates get real clunky when they start drafting these laws is because in many states, not all, some amount of corporal punishment's not actionable. I was going to say it's okay, but I'm not sure that professionals believe that it's okay anymore in any context. But it's not criminal. And it's not even actionable by DYFS. And what I mean by that is some corporal punishment's okay. It's the only way I can express it to you. Because in New Jersey, okay, if you looked at that Title IX that we looked at a moment ago with vexing and profane language and all that, I had the whole book up there, you would see a section that said, and the parent or caregiver inflicts unreasonable corporal punishment. So what is the opposite inference from that statement? That's what lawyers do. They look at a word and they say the opposite and draw conclusions.
Reasonable.
What about reasonable?
Reasonable corporal punishment.
Is
okay.
Okay. It's okay. It is child abuse or neglect if you engage in unreasonable corporal punishment. And yes, the inverse of that is there is reasonable corporal punishment, and that's not child abuse or neglect. In fact, some might say that is okay. You can't get in trouble for it, so I guess you can call it okay. It's not really okay, but it's not actionable, right? DYFS can't come after you. The cops can't come after you. It's considered parenting that's not actionable. And that's in New Jersey. Now, there are some places, I think in Canada, it may have been outlawed completely. Maybe in Wales and the Scandinavian countries, but there are some very progressive nations where there is no corporal punishment that's permissible. One of the more interesting observations about corporal punishment is in Professor Myers' book here. And it's from a couple of child advocates who wrote an article in 1990, Graziano and Numast. Numast and Graziano write, with the exception of warfare, self-defense, and the often necessary use of force by the police, no human interactions other than adult-child interactions carry such clear social support for the unilateral use of physical punishment by one party upon another. Similar behavior, for example, between an employer and an employee carries clear prescriptions and can easily and readily provide the basis for civil or criminal actions. So essentially what they're arguing is, other than war and the police using force to repel somebody who's attacking them, there's no other human interaction where you're allowed to strike someone and not get in trouble. And think about it for a moment. The one context where there is societal support for striking another human being and not getting in trouble, for physically assaulting another human being and it being okay, as we just concluded in New Jersey, is the context between caregiver and child. A relationship where the party doing the assaulting is more mature, is stronger, bigger, and more powerful, and has complete and absolute control over the victim. The one area in life where we say it's okay to assault another human being is an area where the assaulter is bigger and stronger, and the victim has no way out. Now, that's one way to put it. You know, ask any 10 parents, you know, at the Super Bowl party next week. Most of them are going to agree that some corporal punishment is important and necessary and it works. The flimsiest of arguments, but one that's very appealing, one that's heard over and over again, but I suggest is the weakest, is, hey, my father used to beat me up and look how I turned out. I am looking how you turned out, my friend. But, yeah, a lot of people say that. Well, you know, that's the way I grew up. And I'm okay. Really. The American Academy of Pediatrics has wrestled with this throughout the years, and it's kind of fascinating to look at Professor Meyer's book at how they did that. In the first position paper that the American Academy of Pediatrics took, they said the following: spanking is not recommended in infants and children under 2 years of age because escalation, should it occur, carries a greatly increased risk of causing physical injury. There are no data bearing on the effectiveness of spanking to control misbehavior short-term in the average family. Limited data on preschool children with behavior problems suggest that spanking may increase the effectiveness of less aversive disciplinary techniques. Anyway, they go on to talk about the paucity, the little bit of data that says it works. But they kind of go, well, it's not okay here, it's not okay there, but kind of okay here. You know, they're wishy-washy. 1998, a few years later, the American Academy moves beyond that 96 consensus statement, and they say, despite its common acceptance and even advocacy for its use, spanking is a less effective strategy than timeout or removal of privileges for reducing undesired behavior in children. Although spanking may immediately reduce or stop an undesired behavior, the effectiveness decreases with subsequent use. The only way to maintain the initial effect of spanking is to systematically increase the intensity upon which it's delivered, which can quickly escalate into abuse. Because of the negative consequences of spanking, and it's not more effective than other approaches, the American Academy of Pediatrics recommends that parents be encouraged in developing other methods. Here's what the courts have said over the years. The law allows reasonable corporal punishment. Although it sounds oxymoronic, Professor Myers suggests, that phrase is widely used. It's used in New Jersey. The courts in that great progressive state of Iowa said, parents do have a right to inflict reasonable corporal punishment in rearing their children. Hildreth versus the Iowa Department of Human Services. That's Iowa's DYFS. A California statute states that physical abuse does not include reasonable and age-appropriate spanking to the buttocks where there is no evidence of serious physical injury. That's from the Child Welfare and Institutions Code in the state of California. When does corporal punishment exceed reasonable limits and become abuse? That's the dicey area. And again, some argue that it always does. It's never okay. It's wrong. The California Court of Appeals said in '92, a parent who willfully inflicts unjustifiable punishment is not immune from civil or criminal prosecution. It's unjustifiable when it's not warranted by the circumstances, it's not necessary, or when such punishment, although warranted, was excessive. Both the reasonableness of and the necessity for the punishment is to be determined by a jury. As the court states in this Whitehurst case, which is the California case I just quoted from, the facts are what's important. Reasonable, unreasonable, it all depends. But that's the word that governs how we strike children in most places in this country. To discourage undesirable behavior and to encourage desirable behavior. Now, research has suggested harmful long-term effects for some kids. Recent studies suggest that some of the behavior that is a result of so-called ordinary physical punishment. And it includes all the stuff that happens to kids who are traumatized or exploited, right? Alcohol abuse, depression, suicidal thoughts, behavioral problems, low achievement, and future economic insecurity. Now that doesn't mean that kids who are hit as children or grown-ups who are hit as children are significantly troubled as adults, but there's some correlation between that kind of parenting and kids who don't do well as grown-ups. Now, corporal punishment, in conclusion, may be effective short-term. It may stop the kid from banging on the VCR or the DVR with a hammer. It may even stop the kid from ever doing that again when they're real little. But as they get older, it becomes less effective. If it was ever effective at all. But certainly as kids become older, it becomes less effective. And the only way to make it as effective as it was when they were littler is to do what? Yeah, hit harder. You got to hit harder. And eventually they get used to that, and they grow and they get stronger, more resilient. So if you want to get the same result, what do you need to do? Hit really hard. And then they get bigger, then you need to resort to stuff, implements, belts, switches, right? Things like that. I prosecuted a case once. The mother of this girl was troubled. I forget what the problem was. But there was an informal arrangement where she went to live with Aunt A. And Aunt A was very close to her sister, Auntie B. And Auntie A had supervision over her niece. And she lived with her because Mom was unfit. or whatever. And the child, if you can imagine, grew up in the most troubled of circumstances, was a bit of a handful. Not minding Aunt A's rules, who was very straight arrow, church-going, responsible, and had rules, lots of rules. Well, 14-year-old was not interested in the rules and would violate them at every chance. One of the rules was boys. There was a boy, he might have been in through the window, he might not have been in through the window, he might have been over, he might not have been over. Whatever it was, this was the accusation by Auntie A. She didn't know how to deal with it. Nothing was working. The switches weren't working. The yelling, the screaming, the punishments, the smacks, nothing was working. So she calls Auntie B, and they both discipline her, and they take her to the basement, and they take duct tape, and they wrap it around her legs, and wrap it around her wrists, and they beat her as she's bound like some prisoner being transported from the prison to the courthouse, hog-tied on the basement floor. They beat her pretty good. No boy in the house that night. In the short term, it worked. Well, I saw the case on paper, and I authorized the arrest. We very rarely do, like I said, in law enforcement, we very rarely get involved in physical abuse cases unless it's burns and batterings and broken bones and homicides. But we do physical. Unfortunately, we get lots of these. We call them informally belt-whooping cases. But there's belts, there's switches, there's fists, there's open hands, there's all kind of ways that parents batter kids in the name of discipline. But, you know, this case, the kid was bad. You can see she was bruised badly, head to toe. And it was severe. And it was cruel. And she was bound. Right? Well, I go to the first appearance. Once you get charged, you know, you get an appearance for the judge. Before the judge in about 48 hours in many cases. This was in the Superior Court. And I communicated with my detectives, but I didn't meet these ladies. I said, arrest them both. They were arrested. I go to the preliminary hearing. And in walks in these two ladies with a hat on, and you know, a fuchsia suit, and the other one's in a peach blazer. And they're two little church ladies. They look like these are the ladies. And we prosecuted them as aggressively I'd prosecute if, you know, Anthony Galloway walked in with a hammer. But nevertheless, I was a little surprised to see these ladies come wobbling in. One of them couldn't even see. She was nearly blind. You know, she had to hold the paper up real close, and the lawyer had to whisper to her what the words were on the documents that she had to sign. But nevertheless, the lesson there is the lesson of all physical abuse. What did they do? They had to ratchet it up. She was at wit's end. She had to call her more assertive sister over, and they had to take it to the next level. Now, I forget what their background's like, and I'm sure I read their psychological evaluations. But without ever going back and pick up that file, I can guarantee you that they were disciplined that way. I can guarantee you that. And perhaps as aggressively. And probably in their era with switches. Do you know what a switch is?
Yes.
It's a branch or a stick or some kind of whip-like device that usually the kid has to go get, which is part of the discipline and part of the terror. And is part of child discipline in many cultures, or was. So that's physical abuse. Neglect is even harder to define. I mean, there are some typical definitions of neglect, and they're part of Title IX. Erickson and Eglin state that although the bruises and scars of physical abuse are more readily apparent, the quiet assault of child neglect often does at least as much damage to its young victims. This is considered an act of omission. an act of omission. And the only way you can be guilty, okay, in America for not doing something is where you have a duty. And that's just a legal word that says where you have a special connection to someone else or something. So parents have a duty to care for their kids. You know, you could walk by a park and a kid could have its head wedged between the monkey bars and be in dire consequences. And you could walk on by listening to your iPod. Now, morally, you're a total jerk or worse. But legally, you don't have an obligation to save that child. Not in New Jersey. You don't have a duty. Now, in some states, they impose duties. And, the 1990s sitcom, The Seinfeld Show, ended its last episode with a scenario where they were up in New Hampshire and they didn't know about a Good Samaritan law. Some guy was getting beat up and they were laughing and joking about it. They all got locked up. But not in New Jersey. So the parent-child relationship is one context in which you could be charged for not doing something. What do you have to do for your kids if you're a parent? Among many things. Go ahead.
Feed, education, health.
Yeah, feed them, educate them, and take care of them when they're sick. Plus a million other things. But those are the big three, right?
Emotional care.
Yeah. And if you willfully don't do some of those things, you can be charged with criminal neglect. Remember, chapter 24 spoke about abuse or neglect as defined in Title IX, blah, blah, blah. If you don't file your income taxes, that's a crime of omission. But you have a duty. The government creates an obligation for you to do that. So there's a duty there. So by not doing that, it's a crime of omission. Most crimes, you got to do something. Punch someone, kick someone, steal something, right? That's a crime. But sometimes crimes come from failure to do stuff. And in the world of child maltreatment, one of them is neglect. The most egregious form of neglect is called failure to thrive. And, you know, you guys are not in child protection, and many of you are just learning about this stuff. But in the world of DYFS, they see these cases periodically. And I've seen one clear case of failure to thrive across my desk over the years. And it's a phenomenon that it's fascinating. It really is. If you think about it, and you ever want to learn about something that's really speaks to the human spirit and the biology of parents and children and the bonds and attachments, it's this failure to thrive thing. And in part, what this is all about is, if you have a baby, listen to this, if you have a baby and you don't hug it, you don't care for it, you don't coo at it, you don't brush its head, you don't run your fingers along its back, if you disregard, neglect, avoid your baby growing into a 1-year-old and 2-year-old, if you neglect your baby, not food, you can feed the baby, you can give it medicine when it coughs or when it's got a cold, you can give it toys to play with. But if you ignore your baby, if you don't touch your baby, you don't hug your baby, you don't caress your baby, you don't coo your baby, you don't touch its back lovingly, they get sick, and sometimes they die. It's just an amazing testament to that biological, that fascinating connection between the mother, and the child. The simple act of not loving your baby can cause your baby to die. Now, I don't say not loving them emotionally. I mean, you could not love your baby, but hold the baby, feed the baby, caress the baby now and then. But if you totally avoid human contact with a child, they shrivel up and die. It's bizarre, isn't it? There's some research now. I'm a big animal, not so much animal lover. I love dogs. I love my cat, some of you, and you know what it's like, right? Laws are changing to give better rights to animals and dogs and stuff. And, you know, I always thought when I'm done with this, I get offended. Like, child abuse is the worst. And it never really affects me emotionally. But when I see animals, the kids are just as helpless, babies, infants. I've seen the worst of it. The worst of it. And it bothers me, but it doesn't bother me fundamentally. Like when I see animals that are really battered, abused. You know, it makes me want to cry. It really affects me dramatically. And part of me was thinking when I retire, I want to be the prosecutor for animal abuse for the whole country. You know, Barack Obama created a new post, Animal Ombudsman. One of the things that's really, and I just learned about this in large part, was these puppy mills. I knew about the puppy mills for 20 years. I knew my mother felt that we bought a dog that was from a puppy mill. I never really understood the breadth of the problem about puppy mills. You know, I see these places like in Brooklyn, on Avenue Q, Puppy City. I'm like, how could that place breed dogs? Where did they get those dogs from? They get them from the worst places, the worst kinds of places that breed little doggies for profit. And when I'm driving at the analogy that I'm trying to make here is the research that just came out found out that these puppy mills, these are farms. Now, I used to think they were in Kansas, and they are, in Oklahoma, and those big square states where there's lots of land and lots of room. They're in Pennsylvania here. They're in eastern Pennsylvania, these puppy mills. They're probably even in Jersey. You know, they're up in New York State. And you know, like chickens and stuff. They put them in these little square boxes, and they keep them there. They breed them. They have 7 babies. They put them all in one little box, and they put the other ones in a box, and the other one, and the research says even the puppy mills that are clean, even the puppy mills that feed the puppies regularly, even the puppy mills that smell nice, because the assumption about puppy mills is they're all disgusting pits where you don't care about. And there's many of those like that. They're lying in their own feces. They're disgusting. And there's plenty of those where these dogs come from that largely are sold to pet shops. There's human trafficking. This is the equivalent for puppies. Puppy trafficking. And they're not cared for well. And many of them are born in these cesspools. But there are even so-called puppy breeding places that are clean. They feed them 3 times a day. They make sure they get their medicines. But they're kept in cages in the dark, and no one picks them up. They are as severely problematic in adulthood and in the early formative years as any other puppy. There's been this research, and they studied thousands of pups. The puppies who came out of the so-called clean mills are just as bad. When I say bad, PTSD, they can't sleep at night, they cry a lot, you pick up a bottle of milk, they shudder and run. They're just as problematic, just as fearful, just as traumatized as the pups who grew up laying in their own feces. Why? Because nobody picked the puppy up. No one petted it on its head. You know, they're kept mostly in dark. Not complete darkness, but they're not bright. They don't go outside. You know, for the first 3 or 4 months of their existence, they're in a cage. They get the food, they get the shot, they get all the stuff, but they don't get human interaction. It's the same thing with babies as the puppies have. They're finding out that these puppies need contact. If you don't have contact with them, you grow up to be adults who have a variety of problems. So that's a form of neglect, failure to thrive. It's not something you see a lot in law enforcement or indictments, because it's so hard to put your finger on it, you know. And how do you prove that they never picked them up, or never cuddled with them, or never said nice things to them, or were never loving and nurturing? How do you prove that? Well, how do you do that? Not easy. So Professor Myers has a number of other, and we go through lots of different definitions of abuse and neglect. If you go through his writings from page 12 or thereabout, you'll see all of the things that happen to adults who are abused or neglected, that could happen to adults. Anxiety, fear, nightmares, sleep problems, acting out, general misbehavior, withdrawal, regression, okay? Low self-esteem, depression, developmentally inappropriate sexual behavior. All kind of bad things happen to kids that are abused and neglected. These things can begin to manifest themselves as early as their teen years or even younger than that. And certainly can continue throughout their adult years. The consequences are many and they're highly intrusive to their normal functioning. It's sad and it's difficult to deal with people who suffered abuse or neglect as children. The one common diagnosis is post-traumatic stress disorder. And not all sexually abused children have PTSD, but some of them do. There are certain long-term effects. And the most egregious kind of abuse produces many times the worst kinds of outcomes for children going into their teens and their adulthood. Especially childhood incest. I mean, the children who become teens can engage in all kinds of different behaviors that unfortunately undermine their believability, but also make life miserable for them. So these kids can grow up in many cases to be runaways, promiscuous,
Sex workers.
They can get into the sex industry. They can be abusers themselves. They can get involved in self-mutilation and cutting behaviors and other kinds of really significant acting out behaviors. Never mind the lack of trust throughout their lives. It is the most fundamental betrayal to be sexually abused by your father or your stepfather. And that kind of betrayal leads to many of the things that I just rattled off. But the most significant of which, and one that undermines their health and their ability to function for the rest of their lives, is trust. Think about it. How can you go through life meeting people, getting married, having kids, taking a job, interacting with other humans and not trust? If that basic human necessity is obliterated by your father, you will not function as an adult. You'll live a miserable life. Now, sometimes, with the right kind of interventions and the right kind of medicine, sometimes, and the right kind of psychological counseling, these kids who grow into adults can learn to trust again. But it'll never be the same as you and I. And is it surprising? Probably not, right? I mean, if the most fundamental relationship in the child's existence, that is between parent and child, was exploited, if your father or your mother, and it's mostly fathers and stepfathers, if your father or your mother, who God or nature, who biology, who the human condition tells us we should trust blindly, who we coexist with and expect that they will care for us, nurture us, make sure we grow up healthy and satisfied and well, if that person instead molests us and exploits us and uses us, how could you trust any other human on the planet for the rest of your days? So it's not surprising. And it's from this lack of trust and this corollary issue of lack of self-esteem that the die is cast for all kind of future problems. bad choices in men. You know what's kind of paradoxical, strange but true, about a lot of these young people, mostly women who grow up? Not trusting. They won't trust their boyfriend or their husband. They won't trust their teacher or someone they're close to. But they'll meet some bozo in Willowbrook Mall and wind up giving them $500 to join some group. Or they'll trust somebody that they have a marginal relationship with over people who are intimates. Now, if you think about it, it's not so paradoxical, right? Because they were exploited by their intimates. You know, so to trust some bozo they met in Willowbrook Mall who tells them, "I'm going to get you a job," or, you know, "if you do this, you'll be able to lose weight," or, you know, they'll trust all kinds of peripheral people. Yet when they get involved in a heavy-duty relationship, they will not trust them. So it seems strange but true, but it kind of makes sense in the end, right? Because they were betrayed by an intimate. But it's weird that they'll trust some third party who's got no nexus to them with the most suspicious interactions. You know, "Well, give me $500 and I'll do this and that." "Well, he told me this, that, and the other thing," kids will say, or teenage girls or young women will say. "And you believed him?" "Yeah." You don't believe your husband, you don't believe your son, you don't believe your teacher, but you believe this bozo you met in Willowbrook Mall? Anyway, these things, as Professor Myers points out, these kinds of acts of abuse or neglect that happen during the formative years of children have very dire consequences in many kids. That doesn't mean they're all lost and that the outcome is hopeless, but it's real hard. Even the kids who survive relatively unscathed, you know, have long-lasting issues, but they're able to cope, and that's a good day, and that's a good outcome when a victim of childhood abuse or neglect can grow up and cope and function rather normally. And some of them have the biology to do that, despite their circumstances as children. And many of them don't. I mean, we've all heard of the Miss America who was abused, the judge who was a foster kid and raped in Korea, and there's a lot of examples of people who rose above their circumstances to be otherwise healthy or even to achieve great things. You know? I mean, you could rattle off, Hollywood's full of abuse survivors. The lead singer for Guns N' Roses, abused as a kid. Oprah Winfrey, abused as a kid. The Jacksons, what a mess that was. All abused. Every one of them. Roseanne Barr, whatever her name is now, abused as a kid and as an adult. And on and on. The woman on Desperate Housewives, Terry Hatcher, abused. And on and on. Now, I don't know whether there's more there or not, or they have a bigger forum to express themselves. But they're doing well, ostensibly, right? The people I just said are doing well, ostensibly, on the surface. Who knows, what demons are in Demi Moore? I don't know. But I wouldn't be surprised. One of the difficulties in these kinds of cases is that there's a long history of skepticism about women and children, right? Did I make this observation already about people don't want to believe women and kids? Perhaps not. I talked to all different groups. But anyway, there's a deep history, and Myers goes through this in this section here, of skepticism about women and kids. That's why when you're prosecuting these cases, or you're in child protection and you're trying to prove your case so you can keep the family safe, you're in the civil courts, it's hard when you have children of a certain class. And over the years, it's real easy to figure out. Preschoolers, toughest cases. 6 years old and below, toughest cases. Why? Average people, and in criminal context, jurors see them as easily influenced by adults and not good at remembering stuff. Doesn't make for good witnesses. If you're not good at remembering stuff and you can be misled by adults, not going to be a good witness. You need to rise above that. You need a superstar kid, superstar prosecutor, superstar deputy attorney general. Hard cases. Because why? Because there's some truth to that. They don't remember stuff as well as adults. And they are more easily influenced than grown-ups. But it's not as bad as they make it. So a good prosecutor, a good DAG kind of puts that in context for juries or supervisors or judges. They're still able to give good information, little kids, but they get a bum rap. Kids between 7 and 11, 7 and 12, jurors love them. Their memories are pretty well formed, okay? They're not as easily influenced. They're pre-pubertal. They're not peers, they're running around and climbing through windows and all that stuff. They're still innocent. Very effective. 7 through 12, we win nearly all those cases. 13 and beyond, 13 to 18, 19, right? Teenagers, we lose nearly all those cases. Not all of them, nearly all of them. Now, the problem with teens is a little bit different from preschoolers, right? So you got from 7 and below problematic, or 6 and below problematic, 7 to 12, juries love them, we win most of those cases. Then they turn into teenagers, we lose most of the cases. Well, teenage cases, whether it's in the civil arena with DIFUS, abuse and neglect, or in the criminal context, doesn't matter. The reaction by the courts or the juries are nearly the same. And teenage girls are the worst, not them personally, worst kinds of cases. Because of this deep mistrust about women's sexual accusations. Never mind that they're teenagers, and I'm going to go over that in a minute. But throughout the ages, women who make claims of being raped or sexually abused have been looked at with skepticism. And I'm going to give you concrete evidence of that in a minute. So, by virtue of the fact that you're a woman making a claim of sexual abuse, people are skeptical. The presumption is, I don't believe you. Nobody says this, but that's the fact. You better be chaste. You better look nice. You better present well. You better be better than average. You better not be tattooed or pierced. You better not use the F word. You better not be indifferent or angry or rebellious, because I won't believe you. And you will prove the way I feel. You shouldn't be believed. So, women get an unfair shake to begin with. Look at MTS. Right? They go through the history of how women were treated when they were the equivalent of a wagon wheel. They were the property of a man, and your wagon, you had your wife, your wagon, your kids, all of them had currency. They were all the same back in the old days. And, those kinds of things are long-lasting. We don't think that way anymore, but it's hard to shake that kind of legacy. And when women made claims of sexual abuse, they were looked at with skepticism because the perception was that there's a lot of reasons that women make this stuff up. Now, if you said you were robbed in the parking lot at Montclair State, or you went to Willowbrook Mall and somebody took a hammer and broke your window, or you went over to Stuyertown Shopping Plaza and someone slit your tire and you saw them, no one would say, are you sure? Maybe you're making this up. Maybe you don't like guys with blonde hair. They just accept what you say. But if you say that the guy with blonde hair put his hand down your pants, or you said no and he forced himself on you, they go, what time of night was it? What were you wearing? What was going on? How come you didn't scream? How come you didn't yell? How come you didn't get out of the car? How come you didn't call your boyfriend right away? How come you didn't tell somebody right away? All things that women and men and people who are attacked by an overpowering force, something they can't handle, do. So there's this skepticism. There's this suspicion about women who make claims of sexual abuse. It doesn't help. And it really makes my blood boil. It really makes the hair stand up in the back of my neck when I see cases like the Duke rape case, or the chambermaid with the French man who was the head of the IMF, where somebody who makes a claim, and I believe the chambermaid 100%, But I knew the case was doomed. She's an immigrant who came from another country, and immigrants, they do what they can. And not all immigrants, but some people come from such dire circumstances. They'll do anything to get out of where they're at. Lying is what we do. It happens all the time. I'm not saying every immigrant lies, and immigrants as a class are liars. What I'm saying is, you do what you can sometimes to get out of a terrible country and into a good country. That was problematic. And when you lie that you were gang raped in Africa as a mechanism for getting in America, you got problems. Because now you say, well, I lied. That's not true. Oh, you lied about that rape, and you want us to believe this rape? But I think the prosecutor could have gotten past that. But once she started bragging about the prosecutability of her case, and she had some shady relationship with some criminal in a prison somewhere else, she was doomed. And that's what I'm saying. Those kind of cases, now the world says, oh, she's a liar. That case has been branded, he's been falsely accused. He's just some Lothario who was a little too... He cheated on his wife, but he didn't commit a sex offense. The Duke rape case, terrible. Terrible. I won't even get into all those facts. There's a case unfolding right now where the police commissioner in New York City's son, who's the guy on the TV in the morning, I don't watch Fox, I don't watch anything in the morning, but I recognize his face. He's some Fox morning anchor. Kelly, his name is. Ray Kelly's the commissioner of police in New York City. Cyrus Vance, the district attorney for New York, is investigating the case because the police commissioner, I like it. Mayor Bloomberg says, well, I agree with the commissioner 100%. They're doing the right thing because there would be an appearance of a conflict of interest. Mr. Mayor, it's not an appearance of a conflict of interest. It is a conflict of interest. The police commissioner's son is accused of rape. That's a conflict of interest. The conflict of interest isn't bad. It just is what it is. Ray Kelly could be a great guy. And some could be innocent, guilty, doesn't really matter. But that's a conflict of interest. You can't have your father's department investigating. There's a conflict of interest. That's fine. So they gave it to the DA. Now, I don't know. This case looks like it's headed south fast. I don't know what this woman did or didn't do. But the moment her accusation came out, the fact that they met at South Street Shreveport and she brought him to her paralegal office, right away, like, what's she doing that for? And that's puzzling sometimes. Sometimes the questions are legitimate, but the inferences are overdone sometimes. Anyway, these kind of high-profile cases tend to reinforce stereotypes about women who claim to be sexually abused and suspicions and skepticism. So as a woman who makes a claim of sexual abuse, the cards are stacked against you. Imagine if you're a child. Children are largely not believed. People are largely skeptical of them because they're kids and they don't remember stuff well, and they're kids and they're kids and they're kids. Imagine a kid who's a woman and a teenager. Or a teenage girl. Okay, I call that the triple whammy. They're a kid, they're a teenager, and they're a woman. Who believes teenagers? They lie, they smoke cigarettes, they smoke weed, they do drugs, they sleep with boys, they sleep with girls, they do all kinds of wacky things. They're rebellious, they don't listen to their teachers, they're truant. Not all of them, they're very good teens too, but teens are a time of rebelliousness. Right? The last person, the least credible human, is a teenager. Doesn't mean they're not credible, it just means stack them up next to older folks, younger folks. You're going to be most skeptical of a teen. So now you have a teen female reporting sexual abuse. Very rarely do we win those cases. Sometimes I like to tell these 15, 16, 17-year-olds, I don't tell them this, but why don't you come back when you're in your 20s? Because when we have cases where a young woman is now 24, I want to report that my father molested me from I was 8 till 13. And they're 24, what do you do? Well, I work at the mall, everything has to be in a high place. I'm doing this, I'm doing that. Okay, you want to go forward with this? We get to know a little bit about the case and what happened to them. Jurors will be more respectful, more likely to believe the 24-year-old who tells the same story than if that same 24-year-old came to court when she was 17. She comes and tells that story at 17, not guilty. She tells that story at 24, maybe. just because she's more credible now. Go ahead.
How long after the crime can they report it?
Well, the statute of limitations was abolished in New Jersey, so depending upon how old the case is, there is no time limit. But we had a case last week where a woman's reporting something that happened in the 70s. We can't go forward on that because the statute of limitations already expired on that. But in 1996, the state of New Jersey abolished the statute of limitations in sex cases that involve penetration. Endangering, it's 5 years from the 18th birthday. We looked at that endangering statute. But the Chapter 14, I don't want to get into the legal details here, but rapes and sexual assaults and unwanted penetrations, you can prosecute forever. Now, nobody wants to prosecute a case that's 50 years old, but it's theoretically possible. Listen to this. French academics, one of whom was a man named Fournier warned that respectable men are targeted for blackmail by depraved children and their lower-class parents. Okay, now this is 100 or so years ago, so you say, well, that's a real long time ago. People thought weirdly back then, and it's true. Freud didn't do women and children much justice, right? Freud is among the most cowardly of all folks in human history when it comes to women and kids, particularly because of his theories on seduction and Oedipus and all that stuff. Part of Freud's original theories included the belief that many of the women that he saw in his clinical practice, he also treated people, he was a psychiatrist, that many of the women who had a lot of neuroses, they were adults who had a lot of anxiety and low self-esteem, kind of the things we looked at before. A lot of those women are acting out and having all of those issues in adulthood because they were molested as kids by their fathers. What an observation. What a great moment of clarity by Sigmund Freud, right? And this was hundreds of years ago, right? 100 or so years ago, 150 years ago, whatever it was.
100 years.
100 years, was it 18 something?
19.
Oh, I'm sorry, thanks. 1896. Okay, whatever. It was over 100 years ago. But the rest of the psychiatry field, the rest of the academics, the rest of the professionals in Freud's field weren't too keen on this suggestion that fathers molest their daughters and that's why some of these women are messed up as adults. And there was a lot of backlash to Freud's theory. So instead of sticking by his principles, he just retooled it a bit and he sent women and children back hundreds of years. He just retooled his theory a tad and said, well, a lot of these women have life's problems as adults because they fantasize about being molested by their fathers. And unfortunately, that's something that endures. The notion that kids or adult women might make these things up in part because of latent sexual desire for their fathers. By latent, I mean hidden. Not actual, but fantasy. Impacts people's assessments of incest claims today. Now, I think people are more forward-thinking than that. I don't think they would say that out loud. I don't even know if they know it consciously or think it consciously. But when they are so quick to be skeptical of women and children, I think in part of it, it's fueled by the thought that, well, maybe they fantasized about it, or maybe they thought about it, or maybe their thinking's distorted in some way. Freud certainly didn't do women and children much good. Well, you would think that, all right, that's psychiatry and psychology. The legal field, geez, these are lawyers, highly trained practitioners. What do they feel about women and children? Well, before the 1970s, you're going to give society a bit of a pass. People thought much differently then, even in academic circles and even legal circles. And in a pre-1975 journal article, Professor Myers points out children were not the only ones responsible for sexual abuse, according to this article. Mothers shared the blame. In a review of the early literature, Reed writes, mother blaming is as common as victim blaming in the psychological and sociological literature. Mothers of incest victims are routinely referred to as frigid, hostile, unloving women. As women who are cold and rejecting that they cause their husbands to seek sexual satisfaction elsewhere. This bizarre notion that if the woman isn't taking care of her man, he may turn to the children. But not only was that the thought, this was part of the literature in the field 60 years ago. Let's take a look at the legal literature. There's more of this stuff in the social sciences, but one of the most renowned law professors, a guy named Ploskow, said in 1960 that prosecuting attorneys must continually be on guard for charges of sex offenses brought by the spurned female that has as an underlying basis a desire for revenge or blackmail or a shakedown scheme. The Virginia Law Review, now this is 1938, but still, it's a law review, which is the most prestigious of all journals in legal academic circles, said that the rape statute affords promising fields for extortion and malicious prosecution. Well, that's the University of Virginia. Maybe we'll move from the 1930s up to the modern times. Let's bring it up to 1970. And let's get out of Virginia and go to the Pennsylvania Law Review. Penn is an Ivy League school. You go to Penn, people respect you. You went to Penn. You went to Penn? My God, he went to Penn. You went to Columbia, Yale, Harvard. People respect you. Let's see what they wrote in Pennsylvania at the University of Penn Law Review, 1970. The incidence of false accusation and potential for unjust convictions are perhaps greatest with sexual offenses. Women, by the way, this is the law school at Penn. Women often falsely accuse men of sexual attacks to extort money, force marriage, to satisfy a childish desire for notoriety, or to obtain personal revenge. Their motives include hatred, a sense of shame after consenting to illicit intercourse, especially when pregnancy results, and, back to Freud, delusion. In 1952, a law student warned in the Yale Law Journal, Yale, false reports may also stem from another source. A rape accusation is so potent a weapon against a man that a woman may deliberately and maliciously distort the report of the sexual encounter to secure herself money, marriage, or revenge. Well, look, unfortunately, the legal profession is full of these kinds of examples of skepticism about women and kids. But I'm going to quote one last one. We're going to go out west to the Harvard of the West. The number one quarterback in America is Andrew Luck. He's going to be drafted by the Indianapolis Colts. And he plays for the Stanford Cardinals. Stanford is one of the top institutions in America, and as I said a moment ago, referred to as the Harvard of the West. Here's what their law review had to say in 1970-something, quoting from a book. In the Stanford Law Review, although a woman may desire sexual intercourse, it is customary for her to say no, 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 although meaning yes, 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 and to expect the male to be the aggressor. It's always difficult in rape cases to determine whether the female really meant no. Well, how does that set up a model for behavior then? Anything goes. No, yes means yes. No means yes. Silence means yes. What's the point? Back to the Yale Law Journal. Many women mask and require, as part of preliminary love play, aggressive overtures by the man. Often their erotic pleasure may be enhanced by or even depend upon the accompanying physical struggle. Look, I'm not picking this up from trash fiction, okay? This isn't dime store novels from the 1950s. This is the Stanford Law Review, the Yale Law Journal, the University of Pennsylvania. And what's the point? I don't want to belabor it. Listen, times are different. Clearly they're different. But these things are not eradicated from people's perceptions about women and children that easily. It could take generations, if it ever happens. Okay? So what happened in 1975 in the Stanford Law Review or the University of Pennsylvania Law Review was meaningful. And you wouldn't think that it's so close in time to us that people thought this way. But they did and they do. And that affects how kids are perceived, especially women and female children are perceived by the justice system. Children in justice. We're starting out from a disadvantage when it comes to these kind of cases. So we need to do all we can to build the best kind of factual basis to convince people that these things really happened if we believe they're true. Because, to borrow a metaphor from the history of racism in this country, the kids and the women are shackled. You know, there's one hand behind their back, or they're dragging the leg on their leg, a heavy weight, just to get a sense of fairness and equality in New Jersey. The good news is, and we'll end with this, the good news is that New Jersey has been among the most progressive states in America when it comes to leveling the playing field for women and kids. That doesn't change how jurors and average people feel about this stuff. That has to move, unfortunately, at an almost glacial pace. And it'll take a generation or two or more for people to be disabused of that nonsense from the 70s and before. But I got to give credit to the New Jersey Supreme Court and the New Jersey legislature for drafting among the best statutes that govern sexual assault and sexual misconduct, and some of the best collection of case law that levels the playing field for women and children in America. Now, it sets up a very nice model for dealing with these cases in New Jersey. The problem is it's going to take a while for juries to catch up. You read the MTS case. Is there a more progressive and profound case? Well, you don't study cases, but can you think of anything that's more forgiving and beneficial and helpful to the rape victim than MTS? You couldn't have said it any better. Theirs is, I think, the most informed pronouncement on what it means to consent to sexual contact in America. So they set the standard, MTS, elegantly so. But guess what? We don't win MTS cases. Unless the victim said no or objected a little. Now, the juries don't want you to fight and kick and knock yourself out to the utmost. But they still look at the victim and what she was doing or what she was doing. You can't say it, but they think it. And the reason I know they think it is because they find guys not guilty left and right. Where if they believe the facts, okay, they have to convict. There was a case in New York less than a year ago where a drunken girl, young woman, who worked as an executive for Gap, was in a cab. And the cabbie was so concerned about how drunk she was and how she might be in danger. Now, I didn't know who the cabbie was, but you know New York cabbies. He probably wasn't the most sophisticated man in the world, whoever he may have been. He was a New York cabbie. He felt this girl was vulnerable and needed attention and somebody ought to do something, so he calls 911. And the cops come, and they wind up taking her apartment, and the guy raped her while the other guy watched. And he was acquitted. Found not guilty. The cops raped her. One cop raped her.
And he came back a couple times and raped her some more.
Well, then they left and came back. Well, they think he left his wallet there or something, but I'll talk more about that case next week. Shocking, the outcome. And jurors said wacky things like, we believed her 100%, but, you know, I just had some doubt. How could you believe her 100%? She said she woke up unconscious and there was a man with no pants on having sex with her who was half in a uniform. And you know what he said? We'll end on this. He said, well, you know, she was naked except for her panties. And I did spoon with her in the bed, and I did sing Bon Jovi songs to her. I mean, it's so preposterous, it's maddening. I did, you're a cop on the job. You're in bed with a girl with her panties on and no top, and you're canoodling, and you're spooning with her and singing Bon Jovi, and her version's wrong, and you didn't do anything? Come on, man. Come on. Anyway, that's the juries. And I put together a collection of their quotes. They're unbelievable. I believe her 100%, but you never know. You never know. I used to say summations from my great friend Charlie Green, who passed away. The moon could be made of green cheese. I don't know. I've never been to the moon. It could be made of green cheese. But are you going to believe? Are you going to set somebody free because it's possible the moon's made of green cheese? Give me a break. Anyway, we got to go. I'll see you next week.